Welcome to Illegal Minds. As you already know, the topic I'm covering today is murder. Now, murder is quite a funny one because if you've never studied it before as a topic, you most likely have a lot of misconceptions. So it's probably best to discard any preconceptions that you already have because when you enter murder as a topic, when you first begin studying it, it can seem quite confusing if the law on murder doesn't actually match up with your preconceptions. So my advice is to discard any preconceptions you already have regarding the law on murder. But it is really straightforward once you do get your head around it. Now, I'm actually going to do multiple videos. In this one, I'm only going to be covering the Actus Reus for murder, so the guilty act. In the next one, I will cover the mens rea, so the guilty mind. And in another video, I will cover defences, criticisms, and recommendations for reform. Now, just as a foreword, if you don't actually understand the difference between an actus reus and mens rea, you really do need to go and learn the difference, because in order to understand the content of this series, you do need to understand the relationship, or what we call the correspondence, between the actus reus and mens rea. And the reason for that is, for one to be actually convicted of a crime, each offence has a specific actus reus and mens rea that must be fulfilled. So, for example, to be guilty of burglary, the actus reus and the mens rea must be fulfilled. To be guilty of theft, the actus reus and mens rea must again have been fulfilled. Now, there is actually no statutory definition of murder, and for this reason, there is sometimes a lack of clarity with regards to the law on murder. And it isn't necessarily always consistent, and there can also be a lot of uncertainty. And this is partially the reason why the Law Commission has described the law on murder as a rickety structure set upon shaky foundations. But we'll delve into all that when we go over criticisms anyway. We do, however, use a definition prescribed by Lord Coke, who quite a long time ago said that murder is when a man of sound memory unlawfully killeth any reasonable creaturing being under the king's peace with malice aforethought, either express or implied. Okay, now you actually have to isolate segments of that definition because each segment must be individually analysed in every case. So the segments are: number one, the man must have a sound mind, or woman. I don't want to sound sexist, but in law, because of history, we tend to say he or his. The man must have the man must have a sound mind. The killing must be unlawful. The killing must be of any reasonable creature in being. Under the king's peace, that killing must be under the king's peace. And this bit is the mens rea, which we're not going to cover in this video, with malice aforethought, either express or implied. We won't actually necessarily cover each element in that order because, for example, with regards to the first element, that the man must have a sound mind, that's when your defences to murder come in. Things like diminished responsibility, and again, I'm saving that for another video, and it's just more practical to cover defences at the end. Now, as I said, the final part of Coke's definition is only concerned with the mens rea, so the mental element, which I'll be leaving out for this video and I'll be covering in the next one. And so the part where it says with malice aforethought, either express or implied, you can just completely ignore that because that's not the concern of this video. Now, the first question is, who can actually be killed? In other words, what is meant by a reasonable creature in being? Well, the victim must be a living human being. But what do we mean by a living human being? At what stage does one become a human being during the birthing process? Well, firstly, it's not murder to kill a fetus. A fetus is not a reasonable creature in being in law, and that can be illustrated with reference to the case of a child. Now, the case of Poulton demonstrates that the baby must have been wholly expelled from the mother's womb. So it must have been completely expelled from the mother's womb, and thus it's not even murder to kill a baby when it's halfway expelled. It must be fully expelled to be a reasonable creature in being. And the case of Reeves demonstrates that the umbilical cord doesn't even need to have been cut. So as long as the baby is fully expelled, it is a person, even if the umbilical cord is still attached. And the baby doesn't even need to be breathing. And the case that illustrates that is Brain. In this case, it was said that many children are born but do not breathe until some time later. And that's the reason for this principle, is to create a wide protection In another case, Lord Justice Brooks actually said that the law of murder should be as wide as possible, its protection should be as wide as possible, and that one should be deemed not to be a reasonable creature in being only in the most extreme cases. And in this case, I'm not sure what case it is, but in the same case where he made these comments, he gave an example and said that even a conjoined twin with a dysfunctional heart and set of lungs should be protected by the law of murder. So its protection is wide. However, sometimes a slightly more complicated situation can arise. A fetus may be injured but not actually die from those injuries until it is born. So, for example, a defendant strikes a pregnant lady in the stomach, the fetus is injured but doesn't die, the mother gives birth, and then 3 months later the baby dies as a result of the injuries that it sustained during the attack. Now, that wouldn't amount to murder because the Actus Reus was committed at a time when the baby was not, for the purposes of murder, a reasonable creature in being. But in such a situation, the defendant may be guilty of manslaughter. So, in Attorney General's reference number 3 of 1994, the defendant stabbed his pregnant girlfriend, and the baby was born alive but died sometime later as a result of the injuries caused by the attack, by the stabbing. And it was held that no, he could not be guilty of murder, but he could be guilty of manslaughter. Okay, the next question is, when does life end? When does death occur? Now, thankfully, this is pretty simple and easy to grasp. It's very straightforward, and there's only really one case you need to know. The courts have accepted the current medical view as to when a person dies, and it's referred to as brain stem death, and it was approved in the case of NHS Airedale Trust and Bland. It was approved because it's easy to diagnose and it's certain. Either the brain stem death has occurred or it has not. Now, the next segment of Coke's definition to be covered is what is meant by under the King's peace, or as we say today for very obvious reasons, under the Queen's peace. All this really means is that we are all protected by the law of murder during peacetime. The only people that are not protected by the law of murder are enemies of war. So if you're a British soldier and you kill an enemy of war, that's not murder. Obviously, it would be very impractical to convict our soldiers of murder for killing enemies of war. That wouldn't make any sense. So, enemies of war are not protected by the Queen's peace. The position is different, however, when the enemy of war surrenders or becomes a prisoner of war. In that situation, it would be unlawful to kill them because they are protected by the Queen's peace. And finally, there must be causation, so the act done by the defendant must actually cause the death of the victim. Murder is referred to as a result crime. There are many result crimes and murder is one of them. This means that the actions must bring about a particular result, and in regards to murder, that result is the death of the victim. And it's up to the prosecution to actually prove that what the defendant did caused the death, but in the end it's really up to the jury to decide. Now, there are actually two types of causation that we need to cover. These are factual causation and legal causation. Now, let's start with factual causation. It's easier to establish. Now, for this, we use something called the but-for test. I'm sure those of you that have studied tort are already familiar with this test. Well, the same test is applied. It's just different cases are used to illustrate the principle. Essentially, the question is, but for the defendant's actions, would the consequence have occurred? So, but for the defendant's actions, would the victim have died? If the consequence would have occurred anyway, regardless of the defendant's actions, then factual causation has not been established. And to illustrate this point, I would like to refer you to the case of Crown against White. In this case, the defendant intended to kill his mother by putting cyanide in her drink. Now, cyanide is a poison which, when consumed, will rather quickly lead to one's death. It was used in the World War. If a soldier was captured and if he didn't want to be tortured for information, a quick dose of cyanide would have ended his life. And so the defendant put cyanide in his mother's drink, intending to kill her, but she died before consuming it. She actually died of a heart attack. She didn't actually have a chance to drink. the cyanide. And factual causation could not be established because she would have died irrespective of the defendant's actions. And so he did not factually cause her death. Another case is Crown against Dalloway. Now, in this case, a rather idiotic defendant was operating a horse and carriage while going down a hill. But he wasn't holding on to the reins, and so if anything was to go wrong, he couldn't stop the horse and carriage, depending on the distance between him and whatever was in front of him, that is. Now, something did go wrong in this case. A child ran out into the road and was knocked over by the horse and carriage. However, factual causation could not be established because the child's death was probably inevitable. Even if the defendant was holding on to the reins, because of the distance between the boy, he would have been hit anyway and would have been killed. Now, in regards to legal causation, the courts are concerned with whether or not the actions of the defendant are culpable, because the defendant doesn't actually need to be the sole or the main cause of the death. So at this point, the courts are essentially concerned with whether the actions of the defendant are the substantial and operating cause of the death. And it's really important that you understand that. So again, the actions of the defendant must be the substantial and operating cause of the death. So think substantial and operating. Now, firstly, I'll consider acts of God, or what used to be called acts of God. Some people still refer to them as that, but now you can just refer to them as acts of nature or unforeseen events, or any other analogous term that has the same meaning. So things like earthquakes and tornadoes, for example, can they break the chain of causation? Generally speaking, the chain of causation will have been broken in such an event. Perkins gave this example, where A punches B and B is rendered unconscious. If B later dies because an earthquake caused the building that B is in to collapse, then A will not be guilty. However, this general rule only applies as long as the, I guess you could say, naturally occurring event or act of God was not reasonably foreseeable, and the defendant could not reasonably be expected to have foreseen such an event. So, how would the circumstances differ if, say, A assaulted B on a snowy mountain, rendering B unconscious, and there were warning signs everywhere saying that there is a very high possibility of an imminent avalanche? Well, if A just wanders off and leaves B unconscious, and then an avalanche kills B, the general rule that naturally occurring events will break the chain of causation will not apply, and the chain of causation will have been not have been broken. Or, for example, A is at home and watches the news, which alerts him that a very deep and heavy flash flood is on the way. If A then assaults B and leaves him unconscious in the street, knowing that a flash flood is only around the corner, and B drowns, the chain of causation will not have been broken. So again, the rule will not apply if the event that occurs is reasonably foreseeable, or if the defendant can be expected to have reasonably foreseen such an event. The chain of causation can also be broken by a third party if that third party's actions were free, deliberate, and informed. So in other words, they must be totally voluntary. And to illustrate this, I would like to refer you to the very unfortunate case of Crown against Paget. Okay, there were cats fighting outside. Sorry, just one moment. Okay, I'm back. Just had to make sure that my cat wasn't actually getting into any trouble. So, where was I? Yes, Crown against Paget. In this case, the defendant kidnapped his pregnant girlfriend after she ended their relationship, and he took her to a block of flats, in particular to a very dark part of this block of flats, where the police managed to track them down. Now, the defendant began advancing towards the police while holding his pregnant girlfriend in front of them, and he was armed as well. The boyfriend was armed, and he was holding his girlfriend in front of him almost like a human shield while advancing towards the police. And the police could see this silhouette moving towards them, and they knew that she'd been captured by the defendant, but they couldn't quite make out exactly who was in front of them and who was advancing towards them. and so they issued several warnings, but the defendant, while still holding the girl in front of him, kept advancing forward. So again, the police issued a warning, and the defendant opened fire on them. And in response, of course, the police returned the fire for the purpose of self-preservation. But unfortunately, in doing so, they actually killed the girlfriend accidentally, of course. They killed her while firing back. And the court held that the chain of causation had not been broken. Firstly, the actions of the police were not totally voluntary. They were more akin to instinctual reflex reactions, and their decision was certainly not informed, their decision to fire back, as they were in darkness. Their actions were also held to be reasonable acts of self-preservation, and so the chain of causation remained intact between the defendant and the victim. And this case also shows that the actions of the defendant do not need to be the main cause of death, because in this case, the death of the girl was the result of both the actions of the defendant and the actions of the police. But nonetheless, on the facts, it is suffice to say that the actions of the defendant did significantly contribute towards her death, because if he had not have kidnapped her, and if he had not have fired shots, if he had not shot at the police, they simply would not have returned fire, and the girlfriend would not have been killed. And I would also like to refer to the case of Crown against Rafferty, which is again a very unfortunate case. And I actually remember this case making the news. For some reason, it's just always stuck with me. And in this case, the defendant and his two co-defendants befriended the victim, who was a student at college. And while talking on the beach and going for a stroll, they decided to rob him, although they had decided prior to befriending him that they would carry out the robbery. That was their motive, really. And after attacking their victim, the two co-defendants held him down while the defendant stole his bank card and requested for the PIN. I say requested, but the victim probably did not have much discretion on the matter. So the defendant went to the cash point while the two co-defendants and the victim were still on the beach. It was at this point the two co-defendants, for some reason, decided to take the victim out to sea where they would leave him there. The victim, of course, inevitably drowned as he was in no position to swim. He'd just been attacked. The court held that the chain of causation had been broken by the two co-defendants when they decided to assault their victim further and drown him. The reason for that decision is that the joint enterprise between the three defendants ceased to exist, and there was only a joint enterprise between the two co-defendants, because the defendant had left the beach, went to another area, and was no longer in concert with what the other two co-defendants were doing. And now I shall move on to medical treatment and whether or not that can break the chain of causation. Generally speaking, medical treatment will not break the chain of causation, but it can do in some circumstances. The reason it will not usually break the chain is for several reasons. It's to do with public policy, really. Firstly, medical professionals should not be blamed for the consequences of the defendant's actions. Secondly, because as Wilson once said, medical professionals cannot be expected to get it right every time. Thirdly, it could lead to medics refusing treatment. And lastly, medical students should not be deterred from pursuing a medical career. And the case of Crown against Malsharek and Steele involved two conjoined appeals. And the cases were of similar facts, these two cases, Malsharek and Steele. In Malsharek, the defendant stabbed his wife and she needed a life support machine to stay alive. Whereas in Steele, the defendant struck his victim over the head with a large rock, and she also needed a life support machine to stay alive. Now, the doctors, of course, being medical experts, knew that they were probably not going to wake up because the brain scans showed no activity in certain places. I mean, I don't know how it works exactly, but the doctors knew that shutting the life support machines off was the right thing to do. And the issue at court was whether or not the chain of causation had been broken after the doctor switched off the life support machine. And there were essentially two reasons why the chain of causation had not been broken. But you only really need to be concerned with one of the reasons. The first reason, which you don't really need to concern yourself with, I mean, you can do because it helps reinforce what I said earlier, is that because the victims had already died, the chain of causation had not been broken. The brainstem death had already occurred. If you remember what I said earlier, in law, death occurs when there's no activity in the brainstem. That's the current medical view, and that's been accepted by the courts. Now, you don't need to concern yourself with that, but that does reinforce what I said earlier, and you do need to know what I said earlier. But the main reason why the chain of causation had not been broken was because the actions of the defendant were still the substantial and operating factor in the death. Operating as in the action was still ongoing. The victims would not have been in the position they were in. They would not have been on the life support machine if the actions of the defendant had not been committed. And the next case I'd like to refer you to is the case of Crown against Smith. Now, in this case, the defendant and the victim were both soldiers, and they got into a scuffle in their barracks, and the defendant stabbed the victim. And so another soldier picked up the victim, placed him on his shoulders, and carried him to wherever he needed to go to receive medical treatment, but in doing so, unfortunately dropped him twice along the way. And when the victim finally did receive medical treatment, the treatment he received was described as palpably wrong. It was negligent treatment, and because he wasn't given a blood transfusion like he should have been, he was also given the wrong drugs, and the medics failed to diagnose his punctured lung. Now, the medical treatment, as I said, was described as palpably wrong, and it was said that if he was treated properly, his chances of survival would have increased by 75%. Now, that's a lot, 75%. So this treatment was pretty bad. And the courts held that if at the time of death the injury was still an operating and substantial cause, then the chain of causation will not have been broken, even if there was another contributing cause of death. Now, in this case, it was held that the defendant's actions were still the operating cause, so the chain had not been broken. And in the case of Cheshire, the victim was shot twice, and at hospital he was given what's called a tracheotomy, which essentially involves sticking the tube down the windpipe of the patient. Now, his injuries were not actually life-threatening, but he died from windpipe obstruction caused by the tracheotomy. He didn't actually die from the stabbing, he died from the tracheotomy. Nonetheless, the chain of causation was not broken. The court held that in order for medical treatment to break the chain of causation, it must be so independent of the defendant's actions that the jury would regard the actions of the defendant as insignificant. And that was not the case in this case, so the defendant was guilty of murder. So, as you can see, there's a very high threshold. It's very hard for medical treatment to break the chain of causation. There's a very high threshold. It's very unlikely to break it. Even in Cheshire, the actions of the defendant didn't even cause the death of the victim. The medical treatment did. At least that's what the medical evidence showed. Nonetheless, the chain was not broken. And then there is the case of Jordan. In Jordan, the victim was stabbed, but his injuries were non-life-threatening, and he had almost completely healed. But during his hospital sessions, where he would regularly attend hospital, he was given a certain type of antibiotic, which he showed to have a certain intolerance towards. He was essentially allergic. But the doctor continued to give him copious amounts of the drug, and as a result, he died. The treatment was deemed to be palpably wrong, and because the stab wound had healed, the defendant's actions were no longer the substantial and operating cause, and so the chain of causation was broken. Essentially, it was broken on a technicality. The victim had healed, so to go back, the victim was stabbed, and as his injuries were healing, he was attending hospital for antibiotics, and eventually his injury had healed to a point where the actions of the defendant were insignificant to anything that followed. So when he died, as a result of the antibiotics he was taking, as a result of this allergic reaction that he had towards the drug, essentially the wound was insignificant. So the chain of causation was broken. Now I shall move on to the intervening acts of the victim, and in what circumstances the victim can break the chain of causation. In the case of Roberts, the defendant was giving the victim a lift, and while driving, he tried to make a move and attempted to remove the victim's clothing. She then jumped out of the car, and the court held that the chain of causation was not broken because the victim's acts were reasonably foreseeable. Essentially, the victim must act in an unreasonable or disproportionate way to break the chain of causation. And in another case, the victim jumped out of a window while the defendant was trying to break down the door, presumably to assault the victim. And again, the actions of the victim were held to be reasonable, reasonably foreseeable. And so the chain of causation was not broken. Now, the victim didn't die. I don't think this was a case involving murder, but the same principle applies. And what about situations where, for example, the victim is attacked and then refuses medical treatment for whatever reason? Can that refusal break the chain of causation? Well, in the case of Crown against Blau, the defendant stabbed the victim, who was a Jehovah's Witness, and she died after refusing medical treatment. But this did not break the chain of causation. The fact that she refused medical treatment didn't break the chain. And similarly, in Holland, the defendant injured the victim's finger, and his finger became infected. But he refused medical treatment, and as a result, he died. Nonetheless, the chain was still intact. And there is also the principle that you must take your victim as you find them. This is known as the eggshell rule or the thin skull rule. So essentially, if A punches B and B had a thin skull which cracked and led to B's death, A is not absolved of liability simply because B was particularly vulnerable. A should have taken his victim as he found him. And you can use the case of Crown against Blau to illustrate this point. The victim in Crown against Blau was a Jehovah's Witness and therefore refused a blood transfusion after she was stabbed. And the defendant simply should have taken his victim as he found her. Similarly, in the case of Haywood, a wife and husband got into a quarrel. The husband flipped out and chased the wife out of the house down the street. And the victim, so the wife, died of a thyroid problem that was exacerbated by the fatigue she endured running away from the husband. And despite the fact that she did not die at the hands of her husband, the chain of causation was not broken because she had to be taken as she was found. And it did not matter that her death was not foreseeable. This rule applies independently of foreseeability. In the case of Crown against Blau, the defendant may have had absolutely no knowledge of the victim's faith, but that did not matter. The rule applies anyway. And that is the Actus Reus for murder covered. In the next video, I will be covering the mens rea. So, thank you for listening.